3.
Yes.
Before I read that, may I request the court to kindly permit me to show who are scheduled castes and who are scheduled tribes. The definition clause may kindly be used. Article 366.
That which is declared under 341 and 343.
I respectfully agree. But who are declared? What is important for us is who are the people who are so declared? Kindly come to 341. I go down to this observation. Kindly come to Article 341 straight away.
For the purposes of this constitution in relation to each state.
Yes.
Yes. 341 says the president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the caste, kindly mark, the caste, races, or tribes, or parts of or groups within caste, races, or tribes, which shall, for the purposes of the Constitution, be deemed to be scheduled caste in relation to that state or union territory, as the case may be. So the entire list of scheduled castes and the entire list of scheduled tribes are either castes or tribes. Whatever confusion that prevailed among the OBCs, that I'll come to it later. But now consider this. In fact, crux of this matter is a question posed by Honorable Mr. Justice Bhatt on the earlier occasion. What if two words are deleted from 15 and 16, namely gender and caste? Would it not affect the basic structure? If I may say so with respect, that is the crux of the matter. So I have given the details of the races to which the scheduled tribes belong. They are not Caucasians. Mainland Indians are all Caucasians. And all of them, court may kindly take note of it, eloquent submissions are made on a casteless society. Sir, all these tribes are casteless. Why did they stay away from the mainland? Because they did not accept the caste system. That was one of the major reasons. They are very autonomous societies. They live on their own. They never subject themselves to be subordinates or superiors to anybody. And therefore, they remained outside the society. They went to the hills, they went to the forests, and that is where they are living. All of them, they belong to this race. And briefly, I may give the names of certain races. For example, the Northeast tribes Northeast belong to Mongolian race. Tribes like Khasi, Garo, Tankia, Gelong, Minya, Anagamis, Cheslong, etc. And the central tribes, what is very familiar with these tribes, Gonds, Mundas, Santals, Marias, Beals, they belong to Astric race. And the South Indian tribes, like Metakurubas, Jainakurubas, Soligas, Irulas, Kudiyas, Iligas, Pondas, Todas, Kotas, they are from a Dravidian or Negroid or Astric racial features. So just keeping this in mind, Kindly permit me to read the prohibition against discrimination under Article 15(1).
Yes, sir.
The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of. All these tribes have been eliminated from 15(6) and 16(6) only because of their race. No other factor. Are they not entitled to the benefit of anything that is done in the name of poor? Can they be eliminated? As Justice Bhatt was pleased to ask, can the words sex and caste be deleted from 15(1) for any program? Would it not offend the basic structure? Sir, I fall back upon the impact test. Please lift the veil of this provision. Put on the glasses to see who are the affected parties who are eliminated from 15(6) and 16(6). Are they not castes and tribes? Therefore, my very respectful submission is that question of Honorable Mr. Justice Bhatt is the crux of the matter, and it is a clear indication that these two provisions have destroyed the equality code by allowing race and sex to be grounds of discrimination. Supposing a similar provision had been made saying that all positions in the Indian Navy or IAS are reserved for men, not for women, because women already have some benefits in 15(3). Would it be sustainable? Would it not offend the basic structure? If I may say so, in that permanent commission case, this Honorable Court has already declared as invalid any such elimination from being considered for permanent commission in the Indian Navy. So if that is true so far as sex is concerned, in my very respectful submission, even a constitutional provision which eliminates these races, castes, and tribes also hits the basic structure, alters the identity of the Constitution. So both impact test and identity test are answered in the affirmative if we lift the veil of this so-called economically weaker sections to find out who are eliminated. I'll not trouble the court. Enough is said about who are EWS. But who are eliminated, that is very crucial. So I therefore very respectfully submit that this answers the test, both impact test as well as the identity test, because the equality code is turned upside down by enabling discrimination on the basis of race, on the basis of caste, on the basis of tribes. Article 341 and 342 are sufficient to demonstrate. 341 may not be a fundamental right, but it is a basic feature of the Constitution. And Article 46, I'll be giving the list I'm glad Honorable Mr. Justice, but just now inquired, what are the scholarships that are given? I have in my own way compiled a list. I'll place it before you. In 5 minutes, I'll be placing before you. So it is not an official list, but it comprehensively enlists all the welfare measures that are taken in the country and in some states also. And I request the court to kindly mark that in not a single case are the scheduled castes, scheduled tribes eliminated. There may be special provisions for them, but in the general welfare provisions, scheduled castes and scheduled tribes are not eliminated, not disqualified. They are eligible to apply, they are eligible to compete, and they are eligible to be given admission or given appointment. It is only under 15(6) and 16(6) that they will not be entitled to either apply or compete for the post or take any such benefit under 15(6) and 16(6). Yeah.
Yes, sir.
Then one of the substantial arguments in defense of the EWS quota is that SC/STs backward classes are given. Oh, sorry, before I kindly permit me to show the backward classes also, they constitute a collection of castes and tribes that this Honorable Court has declared in a 13-judge decision in Indrasani. I'll give the paragraph. Paragraphs 779, 780, 781, and 782 mechanically.
782.
780. In fact, the whole discussion from paragraph 756 to 779 relates to whether castes can be included and para 781, court says you start with the castes. So castes are included, and what are now included are only castes as of now. There is no further classification which is permissible under this. So this may kindly be taken note of. Say that so not only scheduled castes and scheduled tribes, the entire human sea of eliminated persons for benefits under 15(6) and 16(6) are nothing but races, castes, and tribes, and they could not have been eliminated or discriminated under the provision. That is the bedrock of the equality code. Then kindly come to para 1.2. This submission I have made. I have only given a graphic description as to what happened in Champakam Dore Raja. Kindly come to para 1.2 at page 4. Sir, 14 posts were distributed under 3 categories to 3 different communities on the basis of religion. Hindus were given 12, Muslims were given 1, Anglo-Indians and Christians were given 1. Among the Hindus, Brahmins got 2, backward Hindus got 2, Harijans got 2, non-Brahmins got 6. So this was what was the position under the GO, which was popularly called as communal GO, which was struck down in 2 landmark decisions in Venkatramana for services and Chappakam Dorarajan for admissions to educational institutions. Now kindly come to the next statement, 1.2.2. Now what this amendment has done, it is a very, to put it simply, either applying the impact test, this is what has happened. 100 posts are divided into 5 categories. Scheduled castes, 15 posts. Scheduled tribes, 7.5 posts. Other backward classes, 27 posts. And economically weaker sections, 10. Now kindly stop for a minute before proceeding to the other 40 seats or posts. Now what are these 60 posts going to be? They are going to be distributed strictly according with the communal GO, namely 15.6 and 16.6. 15.6 and 16.6 have converted the entire policy of reservation into what earlier was known as communal GO. 40% may be available, but that by itself will not, as this Honorable Court has repeatedly said, honor the doctrine of equal opportunities. So 60% of the posts to be divided, 50% was already divided in accordance with the Constitution as it stood prior to this amendment. And now the remaining 50% seats are subdivided into 10 and 40, while 10 go exclusively on the basis. So in my very respectful submission, this is hit by the law declared by this Honorable Court in a 7-judge bench decision in Chappakam and Venkatramana. So for this reason also, this needs to be struck down as ultra vires Article 368. Then court may kindly recollect, till this point of time, neither the learned Attorney General nor the other counsel who have addressed have provided as to what is the nexus between reservation and poverty. Why should reservation be given? Why not other measures?
Yes.
There appears to be some obsession that reservation is the only panacea for all ills, poverty, hunger, starvation of screaming millions. That was what was said. Sir, what has that got to do for IAS posts being reserved for them? Starving millions? IPS posts being reserved to them? IIM seats, IIT seats, institutes of higher learning? This is what is popularly known as reverse discrimination. Being obsessed with the concept of reservation. They want to extend reservation to everyone, whether or not that is needed. This has been held to be an unconstitutional exercise. In Ajit Singh 2, the constitution bench, sorry, at para 37, kindly, I'll not trouble the court with the text of the judgment. Kindly come to para 1.8. At page 10. Page 10.
Yes.
What this Honorable Court has said, page 37, para 37, bottom of the page.
Yes, sir.
Kindly come to the bottom of the page. This is
Yes.
also a constitution bench judgment. Thus, this court has to ensure that in matters relating to affirmative action by the state, the rights under Articles 14 and 16 of the individuals to equality of opportunity are not affected. A reasonable balance has to be struck so that, kindly mark these words, affirmative action does not lead to reverse discrimination. In another case, another constitution bench judgment, of course, it is a, I think, dissenting opinion, but the words used may kindly be appreciated. It says, such decisions should not and does not imply that any undue accent on qualifications, the administration can cut back on the larger twist of equalitarianism or may hijack the founding and fighting faith of social justice into the enemy camp of intellectual domination by an elite. The court in extreme cases has to be sentinel on field. This is what has been said. So having said this, my very submission is the impugned amendment deserves to be struck down. Only clarifications which my learned friend, the Attorney General, made a very emphatic submission. Kindly, please. Please. He said, scheduled castes, it is a homogeneous class. Scheduled tribes, it is a homogeneous class. Backward classes, it is again a homogeneous class. Now, with due respects to the learned Attorney General, now this issue is already settled. So far as OBCs are concerned, Indrasani has permitted categorization. Now, on almost all these states, there is categorization. Of course, central OBC list categorization has not yet happened. But in other states, most of the states, in Karnataka, for example, we have 5 categories among the backward classes. So, categorization. So, it is not a homogeneous class. That's what I would like to emphasize. And so far as the scheduled castes are concerned, castes are concerned, court may kindly recollect, as early as in 1965, a committee was appointed by Government of India to go into the working conditions and the problems of scheduled castes and scheduled. They recognized the fact that this is not a homogeneous group and therefore deserves to be differentially treated. That has not happened. Be that as it may, in the latest case of Devendra Singh, 2022 SCC, page 1, 2020. Okay.
The issue has been referred to
Yes.
7 judges.
So therefore, should the issue of SC/STs being homogeneous and therefore they cannot be subdivided into poorer sections and not poorer sections, that issue, with due respects, it is a matter which is pending before a larger bench of 7 judges. And therefore, that argument may not be available. Even among
Just 1 minute, just.
para 27 of Devinder Singh has declared that creamy layer may be eliminated from scheduled castes. And about subclassification, the entire case law is reviewed. In particular, Indrasani is followed, Jarnail Singh is referred to, and then the court says that subclassification is permissible. Paragraphs 35, 42, 44 to 48, 51 and 58. In express words, this Honorable Court, a constitutional bench has declared that it is not a homogeneous class.
That's a
Therefore,
referral order.
it is a referral order. I respectfully agree.
Therefore, it's not
But
something which is a
opinion
final
has been
determination or
Opinion has been expressed
Opinion,
as to
yeah.
why Chinnaya, which declared
Correct,
as
correct.
homogeneous, a bench of coordinate strength has expressed that judgment is incorrect. That is what I want to say. And I'll not read the judgment because my learned friends are eagerly waiting for my conclusion. One last submission before I conclude. One of the justifications given is that EWA's classification has already been upheld under the Right to Education Act. I request the court to kindly permit me to show from Article 21A.
yes.
Right to Education. Under Article 13, Any law that infringes fundamental rights will be hit by Article 13 and it will be invalid. But kindly give a close perusal of right to education 21. The state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Sir, this is a very incongruous provision, if I may say so with respect, which would never fit into the doctrine of fundamental rights. Whatever law the state makes is going to be a fundamental right under this, that is declared to be a fundamental.
The extent is limited by that.
Yes. So EWS category is one such thing. But more importantly, kindly take note of the fact that EWS is an inclusive definition. It includes backward classes, it includes scheduled castes and scheduled tribes. Article 45 as it stood before this amendment, kindly appreciate the fact. In the entire constitution, there was only one provision. No, it is no longer there on the 45 has been amended. That this provision required within 10 years.
Just to take it further, the provision in RTE, that Right to Education Act, it defines.
Yes, it defines EWS.
Inclusive, that is inclusive.
Inclusive.
That is noticed in Pramati.
Yeah, Pramati, yes, I respectfully agree. It has been upheld in Pramati. That's because that it is an inclusive definition, number one. Because SC, STs can never be included from the concept of weaker sections for any purpose whatsoever. And more so, because 21A in its very nature, it gives such a free hand to the state to enact any law which will be considered as a fundamental. And more importantly, this was to achieve the object of Article 45 as it stood prior to amendment, which provided free and compulsory education to all within a period of 10 years. This was the only time-bound program under the Constitution that has now been deleted. So, therefore, my very respectful submission is, Pramati cannot be relied on as an authority to say EWS is. And now I have received the compilations. May I just pass on?
Yes, please.
Sir, one of the questions that was debated was whether Muslims are included in the backward classes. I have given the list of all Muslim communities that are included in the backward classes. That may be found at page 42. All the Muslim sections that are included is at page 42. And the Christians who are included now under 16.4, that list is at page 46. I have also given a tabular statement regarding the number of castes that are subsequently added after the original notification of 10/9/1993 to the list of backward classes. Kindly come back to page 38.
Yes.
Yeah, a tabular statement at page 40 would suffice to say that as on 31/3/2018, 2,513 castes are found in the list of OBCs. Of them, 775 castes are newly added subsequent to the judgment of Indra Sami. Please. Then to answer the query of Justice Bhatt, I have placed all the welfare measures that are in operation under Government of India schemes. A large number of them relate to kindly market, education, higher education, skill development. Kindly appreciate the fact in not a single scheme the scheduled castes and scheduled tribes are involved. So welfare concept necessarily includes.
In fact, they are given special scholarships also.
They are given greater incentives. They are given
One could be specially for the community based and one could be based on
general,
EWS.
all general schemes. I've given the list of general
Yes,
schemes.
emphasis is wherever EWS, they have always been included.
Yes, I respectfully agree. So with these submissions, I thank the court for this patient hearing. Sir, this is for the first time case involving 100% of the population comes up. When reservations in favor of scheduled caste came, it was only scheduled castes who were affected. Scheduled tribes came, only 7.5% were affected. For the general category came, only about 15% were the affected parties and they came before. For the first time, this court is called upon to address an issue which will affect every Indian in the country. I therefore, while thanking the court for expedited hearing, call upon this court to rise to be judicial statesman to strike down this amendment as violating the basis. Great. Thank you.
Lords, I want to briefly respond to the AG and SG submissions with reference to the 50%. That's limited the arguments are going to be. I won't take long. Just if I can quickly take your lordships to 2 or 3 aspects of it. The first, my lords, is this, that I think I was perhaps misunderstood, both by the respondents and I'm afraid the bench, if I was understood to say that Muslims and Christians are not included in the OBCs at all. What I was saying was simply this, that the argument that had been taken thus far was that as a consequence of this amendment, what happens is that you are providing this reservation only for forward castes. I was saying no, in that EWS, you will find, apart from Hindus, you will find Muslims and Christians. Significantly, we have Muslims and Christians in the OBCs. That compilation I've given your lordship will show your lordships that. But we don't have them in the SCs and STs. In the SCs, we don't. And that's why both the 2 commissions which I mentioned earlier, I have in that small compilation I've just handed up. Just give this. I've put the terms of reference of the Sachar committee as well as the terms of reference presentations. And there is a summary. I must say that these committee reports have not been accepted formally by the government. In fact, on Thursday, Mr. Tahir Mahmood, writing in the Hindustan Times, said he is the only living surviving member of the Ranganath Mishra committee, and he wanted to set right the record that appeared to be there that the Ranganath Mishra committee's report had been rejected by the government. He said it's not been rejected, but there are recommendations of ours with reference to all minorities. The earlier Sachar committee report was specifically dealing with Muslims. If your lordship will just come in this compilation for a minute to page number 7, there's a summary there. There's a summary by PRS legislative. And just quickly, this gives the summary of the entire Sachar committee report, which shows light of the Muslim minorities. Specifically at page 8, if your lordships can come, to table 6. Salaried workers employed in government, public and large private sectors. All Hindus, your lordships will find, which is broken up into SC/ST, OBC, upper caste. The SC/STs is 30.4 and public private is 12.8. Muslims is 23.7 and 6.5. These are the numbers here. And if your lordships comes to page 9, page 9, right side column, second last paragraph, poverty, consumption and standards of living.
Which table?
Page 9, right side column, the second last para,
Yes.
there's a heading which says poverty, consumption and standards of
Table 10.
living. Muslims face fairly high levels of poverty. Their conditions on the whole are only slightly better than those of SC/STs, though slightly worse in urban areas. According to NSSO data, overall 22.7% of India's population was poor in 2004-5, 251 million people, with SC/STs together as the worst off at 35%, followed by Muslims at 31%. So these worse off Muslims, the 31%, have to be catered to. And this is possibly one of those measures which can cater to them. Overleaf, page 10, Muslim, OBC and affirmative action. These two paras, if your lordship will permit me. The report compares the status of Muslims who are not listed as OBCs and thus do not qualify for reservations with Muslim OBCs. This is what I was talking about. At least 82 different social groups among Muslims were declared OBCs by the Mandal Commission. According to the last round of the NSSO survey, 40.7% of Muslims are Muslim OBCs, which is 15.7% of the total OBC population of the country.
No,
According to the report,
Muslims are OBC.
So 47% of Muslims
are OBC,
Muslims
are
OBC as
in the OBC. But
declared.
yes, as declared.
They are the 15
But next para, according to the report, the abysmally low representation of Muslim OBCs suggests that the benefits of entitlements meant for backward class are yet to reach them. The conditions of the general Muslim category, this is the remaining 60%, general Muslim category, are lower than the Hindu OBCs who have the benefit of reservation. Please note that. However, the conditions of Muslim OBCs are worse than those of the general Muslim category. The three groups of Muslims in India, Ashrafs, Ajlafs and Arzals, in order of caste hierarchy, require different types of affirmative action. So, this was only just briefly to demonstrate that this argument that this EWS 10% is only for forward caste is completely misplaced. There are several other groups who are also represented. Mr. Ravi Verma Kumar has just shown your lordships those lists. The first page of this compilation I've handed up is to show your lordships how we have expanded these groups. I don't think he was right in saying that, look, this is a discrimination on a race basis that is happening, or a gender basis, or a tribe basis, which are the three phrases he used, saying Article 14 is violated, because your lordships know that, for example, the Meenas in Rajasthan are an ST group. Now, this is not based on a racial characteristic. They are not considered Mongoloid or anything else. It is based on being added. If your lordship sees these three boxes at the very top, it shows from 1950 till now, we have increased these groups from 247 to 736 among the STs, not on a tribal basis or a racial basis. This is the basis of backwardness, and they are tribal groups, not on a racial basis. I re-emphasize, because that was the argument where this started from that example in Nicobar. 318 SC groups has come to 1,283.
One has reservations about these.
Yes.
Because the matrix which is employed for putting a community in an SC or in a, because there's a
Yes.
separate lists.
Yes.
They're entirely different. There are
Yes.
anthropological, ethnographic studies.
Yes.
I don't think we are equipped to get into.
Absolutely. That's exactly what my submission.
Nor are we in a position to say that increase or decrease is.
I'm not saying that. I'm
So I
completely,
don't think this.
I'm completely accepting what your lordships are saying. Therefore, race can't be the basis on which
No, your
lordship will
submission
proceed.
that 10% is not meant for forwards alone.
Yes.
Is certainly.
That's the submission.
That's the point.
And now, if your lordship, no, I'm saying that therefore race can't be the basis for us to proceed in examining this.
Your point is taken.
Yes.
The point which is being emphasized, argued by Professor Verma also, Ravi Kumar Verma sir today,
Yes.
and earlier council also. This is that exclusion,
Yes.
SC, ST and OBC,
Yes.
that the persons.
Correct.
16.4 and 5,
Yes.
15.4 and 5, out of this 10%, that
Correct.
is the problem.
Yes, that is the
the
point.
point.
See,
No, that
just
is-
to illustrate,
argued.
just to illustrate what.
Yes.
Whatever communities are OBC, and
Yes.
you pointedly mentioned Muslims.
Yes.
The interpretation which more or less both of you suggest.
Yes.
Both sides seem to
Yes.
suggest, is the other than means that the 14 categories, that, such of them who are in this 40% of these, who are in the OBC,
Yes,
they are excluded from consideration.
Yes.
That is the one which is.
yes,
attacked.
that seems to be what they have gathered. Now, if your lordship will pick up this chart, this is to compare the position prior to this amendment and post the amendment, because your lordships may note that the AG very specifically, and the SG has adopted this, said that this additional 10% falls in a separate compartment. Therefore, your lordship will recall when I argued, there was a soft option and the hard option in the addition to the existing reservations. Your lordship were kind enough to suggest that, look, maybe the soft option can be adopted. The position the government has been taken is to put an obstacle there and say no. The SC, ST, OBCs are essentially untouched. It's a separate compartment where you have a 50% ceiling limit. Over and above, separate from that, separate but equal, you have this 10% which is for a EWS. In my view, if compartmentalization of this nature is permitted, we are effectively going to go back to a Champakam kind of situation where you're going to compartmentalize each group and say that we have compartmentalized. I don't believe compartmentalization is at all a phrase that you can use when you're dealing with enabling provisions like this. Because the minute you add this compartment, it takes it above 50%. And then tomorrow they come with an additional compartment. They will call it a compartment, have a vertical reservation for another group. It may be some other disadvantaged group. And this compartment argument will be used to take it all the way to 90%. Take a look at the effect today of this chart. These are not compartmental. Picture one is what it stood now. I've taken for an illustration 100 seats or 100 posts. This entire chart on the left side is 100 seats, split into 49.5, which are the yellow, and 50.5, which are the general. I've put the horizontal reservation, that's the women, that's W. EX is ex-servicemen, and PWD is persons with disabilities.
This, sorry, Mr. Shankar.
Yes.
To interrupt you, sorry.
Yes.
Even this may not be correctly means
A
depicting
depiction
the
of it.
position which is existing. Compartmentalization as such you can't deny. So far as SC, ST and OBC, in that 49.5% also, there is compartments, sir. There are compartments.
No, I'm not done.
The SC is not well.
Cannot get a reservation.
Going to SC
That's of course.
and so on, right?
Yes.
So those compartments are indeed there. EWS also as conceived.
Yes,
This is a compartment.
yes,
Obviously, we have to take it to be a compartment. What
Yes.
we are saying is, sir, that the focus of this entire debate ultimately would be whether it hits, whether it affects, whether it alters the basic structure or not.
precisely.
So let us concentrate on that.
I'm-
aspect,
I'm-
sir. All these statistics may not ultimately.
Which is-
see on the matter, that is what we feel.
Which is precisely what I'm doing. I'm explaining that the argument today in an enabling provision under the Constitution is only between reserved and unreserved. That's all. Creating an artificial classification in among them, saying that compartment for OBC, compartment for SC, compartment for ST, and compartment for EWS, and arguing, and this was their argument, that 3 of these compartments can go up to 50%. The 4th compartment is a separate compartment, is no argument at all. I am saying, as far as the reserved, vertically reserved are concerned,
You're presenting,
the ceiling,
what you're presenting as horizontal
yes,
actually may not be a feasible option. It could be feasible up to the OBC point. For OBCs, Andhra Sani says you can categorize, and there are categorizations, as Mr. Ravi Verma Kumar said,
yes,
in different states, but we don't know really.
yes,
Which is, if you're going to strictly apply the income criteria and ignoring the 50%,
yes,
just keep aside the 50%.
yes.
The one way is the horizontal way you're presenting. If you were to further it, then you present it vertically. In
This
that
is
part-
only a vertical presentation. I don't know if I was permitted to explain. This is purely a vertical. It's only just so that I can show you the horizontal also. I put the letters in. This is only vertical. Yellow is reserved. Green is unreserved. Ignore the horizontal. Ignore all the letters in the middle. That's only to illustrate for your lordships that there is a horizontal existence in this. Otherwise, yellow
This,
Is-
you're right.
Yes.
If you don't see this as horizontal, it
Yes.
becomes vertical and
It's only vertical. I'm trying to
everyone
explain.
is seeing that.
Yes, I don't want to be faulted saying you left out the horizontal, so I put those letters in to illustrate that there is.
Come back in.
Yeah.
activity which is subject to disqualification and you leave and you proclaim yourself as a separate group, but don't merge. You have voluntarily given up membership. Whereas if you have given up membership, with greatest respect, how does para 15 apply? That too by the sole applicant before the election commission, Mr. Eknath Shinde. Who's the sole applicant? There is no other application. Today, Manas, your lordships can always decide, but today, Manas, he is under a cloud, under the simple text of 218.
All right, Dr. Sibhi, thank you very much. We'll just take a short break and we'll be back and we'll hear these.
Balance of convenience of lordship does not have any impression that your lordship has some imminence or urgency.
Mr. Sibal made the point. We saw the of those orders. We can just see those for a moment. That's all that we'll share.